share the screen with you all. Can anyone tell me please how to share the screen, because I have a presentation I'd like to give.
Ma'am, there is
Oh,
a green button in the center, share.
understood. All right. Let's see here. Ah, yes. Okay. All right. Can everyone see this presentation? It says intellectual property laws in Pakistan. If I can get someone's yes or no, then we can start.
It's a blank screen, ma'am. We are not
It's a
able to
blank.
see it.
I
Yes,
believe it's
yes, we get it now. We get it now. It's visible.
all right. Okay. So this is a presentation on intellectual property laws in Pakistan. We will be talking about, this is an overview on patents, copyrights, and trademarks. So a little bit before we actually move on to talking about the gist of the actual meat of our discussion, and Ms. Baloch has given a very wonderful introduction on Sir Osman. This slide is just a little introduction on Sir Osman. And basically, when we're talking about intellectual property law specifically, Sir Osman, I can say with a very high degree of confidence, mashallah, that he has litigated in various trademark and copyright cases and has taught the law regarding patents and represented clients wishing to get their patents registered. They've also represented, he's also represented major clients such as the Oxford University Press and Multiform Limited. So these companies, their intellectual property rights, for those rights to be protected, it's obviously a big deal to them, right? Having their patents, their trademarks, their copyrights, or whatever else it is, right? Such as designs and such. For big entities, such as, you know, academic or business entities, for their intellectual property to be acknowledged and enforced and protected. Sir Swan has done a real stand-up job of that. And inshallah, I hope to follow in his footsteps. A little bit about me. I graduated from UOL since August 2023 with my LLB, and I currently, alhamdulillah, hold a membership and license in the Punjab Bar Council and the Pakistan Bar Association. I'm also pursuing membership in Canada as well, my legal career in Canada. As of right now, I am an associate of Pakistan Legal Research in Jeddah, Saudi Arabia, where I'm currently residing. Pakistan Legal Research is headed by Sir Sayyid Muhammad Ali Raza, and it is my position right now in the firm, and it's an NGO initiative basically. My job is to write legal research papers, and inshallah I'm hoping to write on intellectual property as well. So when we're talking, again, when we're talking about intellectual property, my work, especially with Sir Osman, has revolved a lot around artificial intelligence and its implications in intellectual property, which makes sense given how Pakistan is a very open country when it comes to artificial intelligence, is open to the idea of using it, but we still need a little bit of guidance as to how and what the implications are. So, Bismillah, let's start with actual intellectual property discussion. So what actually governs intellectual property in Pakistan? Now, the IPO, which aligns itself with the WIPO is the World Intellectual Property Organization. It is Pakistan's regulatory and authoritative body established under the IPO Act of 2012. So it basically guides and is guided by Pakistani legislation on intellectual property. So the IPO has what is known as its policy board, which is comprised of a chairperson and members who develop, enforce, and safeguard rules protecting IP rights and their implementation. They help to approve policies, create new ones for funding and executing tasks, and helping people get their intellectual property recognized. The IPO also refers to Pakistani legislation, such as the CRPC of 1898 or the Criminal Penal Code of 1908, depending on the infringement that is being addressed. And as we will talk about more, what is the optimal method of and who is the proper forum to resolve it. The IPO also has a director general who acts as its overhead security and is responsible for monitoring daily operations and assisting the board in creating and enforcing new policies. As I've said before, the IPO refers to statutory legislation such as the ones that I've listed here. Especially in our discussion, we will be talking about the trade ordinance, the copyright ordinance, and the registered designs ordinance, and of course, as you can see, a bunch of others. Like I said before, the IPO aligns itself with the WIPO, and so all of its operations work in line with the WIPO. And the IPO's main administrative authority is the tribunal. So the IPO tribunal is presided over a Pakistani High Court judge or a sessions or a district court judge, depending on kya munasib samjha jata hai at the time, or an advocate qualified to be a high court judge. So when we talk about the infringement and the post-infringement enforcement of an intellectual property right, there are three main forums that resolve these issues. One is the IP tribunal, as I've spoken about just now, or the police, so law enforcement, or the judiciary. Let's talk a little bit about patents first. So patent law and the Patents Ordinance 2000 is important, and it's basically the main guiding text for our discussion on patents. So what makes a patent credible in the first place? What makes an idea patentable? So as per Chapter 3 of the Ordinance of 2000, it has to be an inventive product capable of industrial application. So patents, that means that patents are not usually for artistic works. Trademarks and copyrights, those are more so used to legitimize artistic works and the proprietors that own those works, say, or the intellectual property to those works. So these things are basically and patents are basically for industrial use. So things like scientific inventions or discoveries, medicinal discoveries or inventions, people's industrial or engineering inventions, things like that. More right-brained stuff, or is it left brain? Whatever part of the brain is considered to be more logical and technical, that sort of thing. Now, the most important thing about what makes an idea patentable is that the patent idea has to be novel. And Chapter 3 is very clear when it says that Pakistan's peoples and cultural heritage, it involves so many ancient inventions, so many things that we don't even know about yet until we really start learning about them. So we need to make sure that the patent in question, the idea for which we are seeking a patent in question, is so unique that it isn't even ancient, that we're not just appropriating and marketing as ours someone else's design. For example, there are ancient Punjab inventions and practices of agriculture and irrigating water, as the Punjab has been considered one of the main breadbaskets of the subcontinent and of Pakistan, right? So we want to make sure that if I have an idea or a patent idea for irrigating and farming, that it's not mooching off of anybody else's idea, that sort of thing. Now let's talk about, let's talk a little bit about how can we get our patent registered and applied in the first place. So who's eligible to apply anyway? Again, you have to be the real true proprietor of the invention concerned, or an assignee of that person, or their legal representative, again, acting as an agent for them. The first thing you want to do, like I said before, you want to make sure your idea is original. And then when filing your application, there are a bunch of particulars that you have to be careful for, certain forms to fill out, certain specifications, certain particulars. Particulars is basically what we like to call this. So, masalan, details of the applicant, inventors, addresses, etc., what the patent is for, that sort of thing. You want to make sure from the outset, from the get-go, you are clear when it comes to referring your application to the Pakistan patent offices. You don't want to give them questions of, or a lack of clarity. So again, once you have this done, you want to certify and submit a copy of your priority document for the patent, basically like a all-encompassing document. Your application will be submitted to the relevant Pakistan Patent Office, and if it's successful, it will be included in the Register of Patents, wherein the public, or from which the public will know that your patent has been legitimized and registered. Now, let's see here. Let's talk a little bit about how to apply, or the application of your IPO, right, when regarding a patent. So of course we have applied for it, and then the patent has to be publicized. So when specifications or particulars are complete and have been accepted, you will be notified to advertise the application. Now, in the official gazette. At this point, you're this close pretty much. You're just a step away from getting your patent publicly recognized. It is recognized within the official gazette, meaning it just needs a little bit more scrutiny, a little bit more tweaking if necessary before the patent is officially granted. Now, patent examination is our third step in registering and prosecuting IP for patents here. The report for this is usually filed within 14 to 18 months after the patent is applied for. And if the objections that are made, they have to be rectified within 12 months after that first exam report is issued, after which the application will be included in the official journal if it is okay by that point. Pre-grant opposition अगर है, अगर उस इस stage तक यानी कोई नहीं opposition, then all good and well, we go straight to step 6, your grant of patent. If there is still some pre-grant opposition at any time within 4 months after a complete particular has been advertised, the application may be granted despite being limited in protection afforded to it. क्योंकि there may be certain limitations even if your patent is accepted. Why? Because you've gotten so far ahead in the registration process that it's a little unusual if even at step 5, like right before your patent's granted, if there's still things that need to be tweaked. It sort of lessens confidence in the patent's legitimacy, even if by an atom's worth. So there are certain limitations that might be afforded to the patent, even if it's granted. Not always, but sometimes. Now, when we're talking about the grant of the patent, the applicant makes a formal request for the application to be accepted, reiterating that they've done everything they were required to do and no objections were made, or if they were made, that they were not left uncorrected. So they've been addressed and resolved. Finally, the application is published in the official gazette and holds a term of 20 years from the date of application, after which the invention patented falls within the public domain. All right, now, after a patent has been granted, why might it be revoked or canceled altogether? We know that a patent can be revoked or refused before it's registered, but what about after? So there are 3 main reasons that revocation or cancellation might be handed, either by the High Court, the controller of the Patents Office, yeah, you can just say Patents Office, or the federal government. If the High Court itself has revoked your patent or your application, the federal government, it's because the federal government has delegated it to do so. It has found itself unsatisfied with the creation, use, or exercise of your patent in question. This is because, as we recall, patents are industrial intellectual property markers. And so the property in question is industrial, and so it needs to promise itself to the government as being beneficial to the government or to its sectors of industry. So if it's not, then the federal government really has no use for it. कोई फायदा नहीं है. So the federal government either itself or delegates to the High Court your patent isn't useful to us, there's no reason to keep it around or recognize it. Now, if the Patents Office itself has privately, revoked it, that won't happen unless the applicant was provided the opportunity to make it all right before or be heard before their application status is finally decided. Now, like I said, revocation that comes from the federal government is handed because the applicant failed to make use of the patent to the benefit of the government or Pakistan as a whole. So in that case, the federal government might delegate revocation to the High Court. However, if your exercise of one's patent is outright prejudicial to Pakistan, then the federal government will take action itself. Especially because in a free market economy like Pakistan's, if you act in an anti-government way, if your patent is used or manipulated to be anti-government as in prejudicial to the interests of Pakistan's economy and industry, or it is downright anti-competitive, then it will be revoked most likely. So before we move on to copyrights, there's an interesting case I'd like to talk to you about. We just slowly but surely move over to this lovely green bubble here. All right. Yes, patent case law. An interesting case is the US versus Pakistan 1997. Now, this was for patent protection for pharmaceutical and agricultural chemical products. Now, why is this important? There's a bunch of text here, obviously, but I'll condense this for you. The main point of this case was establishing that Pakistan will not engage in litigation when it comes to its intellectual property laws unless the forum is something that Pakistan has agreed upon. As you may recall, I told you that the IPO, intellectual property rights are enforced and made, they are addressed or cognizance of by either the IP tribunal, the courts, or the police, as in law enforcement. So here, in this case, the US, in its request for consultations dated 30th of April 1996, claimed that Pakistan was violating its own, the US's and the WTO's TRIPS rules, as they are intellectual property rights rules, as well as the IPO and the WIPO's rules on protecting intellectual property rights. So the US requested the DSB, or settlement body from the WTO, to help solve this issue. Since Pakistan said, well, the WTO is neither the IP tribunal, nor is it the courts of Pakistan, nor is it the law enforcement of Pakistan, we're not going to engage in this through litigation any further. So both parties reached a mutually agreed position, and they told the DSB that their amicably made terms were being drawn up. So even if forums, as we know them, cannot be utilized, or they refuse to be utilized, or not recognized to be used, such as the three ones that I've talked to you about, a lot of the time, IP rights can also be, consolidated between parties privately through alternative dispute resolution or any other avenue like that. Other notable cases include Getz Pharma Limited versus Servier Laboratories and another 2014, and Muhammad Shah Kakar versus Intellectual Property Tribunal at Sindh and Balochistan and others 2020. Now, we've talked about patents quite a bit. Let's talk more about copyrights and trademarks, because copyrights and trademarks are made for more artistic, literature, media-based works. So, and that's something that younger people like you and I are a little bit more interested in. At least I think so. So, copyrights and trademarks and patents, their application process, their registration and ownership process, it's quite similar. So I'll condense all this text for you. The first step is applying to get your copyright registered and sending in certain particulars, sending in certain specifications, details of your copyright, what the copyright is for. Is it for a product? Is it for a service? Or is what you're wanting a copyright registered for, is it both? That sort of thing. And so inspection of these or assessment of these application particulars are done by the Copyright Office and the Copyright Board. Now, and of course, as you might have figured, there are certain fees to be paid via demand draft to the IPO's Director General, or admission application fees, renewal fees, that sort of thing. That's sort of like a given. Now, third step is advertising or publication of the copyright. This only concerning acceptance of artistic works, because products, for example, for which copyrights or trademarks are made, masalan soda, for example, those are in the public view anyway. But art is a little bit more private. Art sort of is publicized differently. It's not like you can just sell art in the market. It's a little bit more exclusive, maybe because of the influence of high culture and its use of art, but whatever the case may be, usually artistic works copyrights are advertised or publicized, and then that publication will be analyzed by the registrar of the Copyright Office, and this is done according to the Copyright Board Procedure Regulations of 1981. So not only does the Copyright Ordinance of 1962 have significance, but so do the regulations of 1981. These laws these rules work hand in hand. Any oppositions made will be heard and determined as per Section 46 of the 1962 Ordinance by the Copyright Board, which is comprised mainly of a chairperson and 5 members appointed by the central government, and registrar with regard to expertise in copyright-related fields such as photography, art, writing, cinema, literature, that sort of thing. And that makes sense, because if you are scrutinizing the legitimacy of a copyright for a certain work, you want to be an expert in that kind of work, that industry. Afterwards is the fortified registration of copyright. That's pretty much your last step. You've made it. You are now a proprietor of the copyright, and you are issued a prima facie evidence certificate. Basically, it acts as prima facie evidence. As we know, this legal term means that in this case, that the proprietor does indeed own the copyright. It is outright evidence of that. When it comes to renewal, as per Section 18 of the ordinance, a copyright needs to last, or does last, for about 50 years, after which renewal is necessary, lest it is removed from the copyrights register. Because again, newer intellectual property rights and their registrations come up every year. Inventive in Pakistan. So now let's talk about licenses and licensing and agreement. So as per chapter, I believe that is chapter 17 of the ordinance. So licenses by copyright owner, existing or prospective owner may grant any interest in their copyright via a license signed in writing to them or their duly authorized agent, to take effect once the copyrighted work comes into being. Yani ke, a copyright owner, once they are registered as the true proprietor of a copyright, they can delegate ownership as well. A compulsory license in work withheld from public. If ever during the term of a copyright, an application is made to the Copyright Board that the copyright's owner has refused to allow any republishing of their copyrighted work, or they refused the public from benefiting from it, or that they are dead, unknown, untraceable, then where 2 or more people have made such application, the license is granted to the applicant thought by the board to best serve the public's interests. The federal government or the Copyright Board may, upon application by a government or statutory institution in the public's domain, or interest, grant a license to reprint, republish, etc., that copyrighted work, even if on a non-profit basis, because again, especially if the copyright owner is dead or has not been heard of, there's really no profit to be made from that anyway. License to produce and publish translations. Anyone in Pakistan may apply for license to produce and publish a translation of a work in any Pakistani language, not being English, French, or Spanish, because even though English, for example, is an official language of Pakistan, it's sort of a given that a certain work in Urdu or Punjabi or Pashto or Sindhi, for example, etc., will be translated in English as well. So application prescribes proposed retail price of a copy and the fee paid to the registrar as may be required. License granted herein is not an exclusive license. An applicant shall pay royalties to the copyright's owner as determined by the board. So especially if this license is delegated, right? Licenses herein may be granted in exceptional circumstances as well, such as, for example, if the applicant did all they could to request and receive authorization of the actual proprietor of a certain copyright, but has not been able to locate them. Again, maybe the proprietor has passed away or they have not been heard of for a long time. Maybe their work is so old, right? Or wherein the board is satisfied that the applicant is competent enough to republish and produce this work and pay royalties to the actual proprietor of the copyright. But what do we do when copyrights are infringed upon? We talked about how we can force the implementation and respect of a registration of a patent. What about copyrights? Now, when we talk about copyrights and trademarks, a lot of the time, good faith and fair use comes into play. So what about that, right? Masalan, as you can see, this graphic that I've included, criticism and parody tend to be fair use. So um, for example, certain parodical works of movies, certain reviews, right? Certain clips, those tend to fall into fair use. But so then what actually is an infringement? अगर ये सब जायज समझा जाता है, तो फिर गलत क्या समझा जाता है? What is an infringement? An infringement occurs when anyone not authorized either as the copyright's owner or on the owner's behalf does anything exclusive to the rights of that owner as under the Copyright Ordinance 1962 or allows for activity or profit gained from which that infringes upon the rights of the copyright's proprietor. So that's a lot of words. What does that mean? Basically, it means that if it prejudices the real proprietor of that copyright, that's called an infringement. This can also happen when offers for sale or hire or distributions for aims of trade are made to the extent, again, that the actual proprietor is prejudiced. Most times, in the context of money lines perfectly what is proper and legal to do, which is distinguishable from an infringement. As we said, criticism, parody, fair dealing or use would be purpose of research, broadcast, education, judicial proceedings, of course, many documents come into the judicial proceedings domain, recitation, review, that sort of thing. So let's move a little bit over here. So we know what does and doesn't fall into an infringement. What about when it does? What can we do in terms of infringement proceedings to enforce and remedy these? The owner may claim for injunction, damages, or accounts, or whatever is deemed fit by a district judge, because jurisdiction may be granted to it under Section 65, provided that the accused has the opportunity to prove, if they can, that they did all they could to make sure that what they did was perfectly legal. They took the precautions necessary. They did not mean, essentially, to infringe upon the copyrighting question. If they can prove that, if the accused can prove that, then the plaintiff is only really entitled to two injunctions. What does an injunction do? An injunction is a stop to future violations. It doesn't really account for past violations, right? So applications submitted by the proprietor includes descriptions of laws it is under and what remedies are being sought. And basically we can say कि किस हवाले से, किस वजह से और किन remedies को pursue करते हुए एक application court तक भेजी जा रही है, right? या पेश की जा रही है. So special remedies, besides injunctions, damages, accounts, etc., special remedies may also occur or exist in the form of interim orders, right? So when does this happen? This is especially the case if delay is likely to cause the plaintiff additional prejudice. So interim orders act as stand-in orders before formal injunctions, damages, or accounts are granted, because litigative processes can take quite a little bit of time, and so we want to make sure that the rightful proprietor of a copyright is not prejudiced, because that's exactly the sort of thing that the judiciary is trying to prevent. Now, besides the police, the IP tribunal, the board, the law enforcement, what else can help to redress a certain infringement of a copyright? It's the Copyright Board's committee. Now, because the court delegates authority to the committee to make a decision, its decision is considered final. In fact, it's not just considered, so it is final, right? So that means that no other court or forum is to hear the case at hand. Penalties are described in Chapter 14, I believe, offenses and penalties, such as punishment for making false register entries or tendering false evidence, resulting in imprisonment for up to 2 years or a fine of up to 100,000 rupees or both, as per Section 68. Now, a magistrate of the first class, in case they hear a suit, can dispose of infringing copies of copyrighted works once cognizance has been taken of that infringement, and award can also be compensated to the aggrieved for what they suffered, again, mostly in terms of profit. Appeals against these orders can also be made against the magistrate's decision or that of the registrar, and sometimes even the board, except for its committee, on grounds of grievance or disagreement. Now, what's the most relevant in our time is artificial intelligence and the implications that it has on intellectual property. Before I talk about this, though, I just want to say that remaining meeting time will likely like 3 minutes. So I'm not sure how we might be able to um, uh, how we might be able to manage that.
We ha-
Is there any way to extend the
no, ma'am. We have to rejoin with the same link.
one second? Um, Hello. Can everyone hear me or not? Okay, uh wait 1 second. Can everyone hear? I believe Mr. Muhammad Omar has said yes, but I just want to confirm. I will ask Mr. Anil. Okay, great. Okay. Assalamu alaikum again, everyone. Hello. We are going to continue with the little presentation I've got for you. Maybe not so little. So we were talking about, oh, excuse me, I need to share my screen again. We were talking a little bit about copyrights this time. So what is it about copyrights that need to be protected when it comes to digital works, right? Copyrights for specifically digital works. Let's see if everyone can see my screen before I go ahead and present. All right. Can everyone see my screen? Okay. 1 second. Can you see? I just messaged Mr. Anil just in case, you know, can't see the chat actually. Okay, great, 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 great. Okay. Excuse me for stalling. So protecting copyrights for digital works. So unfortunately, although Pakistanis use and employ works on the regular, I mean, we're doing it too, right? There's practically no legislation protecting digital works or copyrights corresponding to them. That's quite problematic again because we're a burgeoning country. We are, we've got a burgeoning software, population in terms of like not only consumers of software and digital works, but the creators of that as well. So even though numerous laws protect goods and services and copyrights, trademarks and other intellectual property denotations that are attached to them, such as the Sale of Goods Act, 1930, the Islamabad Consumer Protection Act, a bunch of others, they don't really account too much for digital works because uh, these goods and services, that label doesn't always fit so great when it comes to digital works, right? Additionally, artificial intelligence is a very, a newly arising, because I keep saying the word burgeoning, so let's use a synonym, a newly arising, if you will, area of the internet and computer science. And it holds a lot of importance in our discussion when it comes to intellectual property and law generally as well. However, suggestions suggestions have been made to include AI under the protections afforded to copyright, for example, such as being categorized as a literary work or being protected as trade secrets, as they are protected. But there hasn't exactly been a set legal framework on that yet. So a lot of academics and pundits in Pakistan, lawyers in Pakistan, they suggest, and I would suggest as well, that there has to be set legislation, not just hypothetically conceptualized rules or policy. There needs to be set policy for the protection of digital works and their copyrights so that infringements can be addressed and corrected, and so that the importance of digitized works in Pakistani society are reflected through legislation as well as common law application. क्योंकि जब तक legislation नहीं बनता, the common law application doesn't have a foundation for it doesn't have it's not inspired anyway, as well as demonstrated compliance with the WIPO's internet treaties. Again, because the IPO works in line with the WIPO, it will be able to further do so by creating treaties and set policy the same way that the WIPO has, or at least complying with that, or working in line with that of the WIPO. Now we've got a little bit of case law that we can discuss. this work is sort of, this presentation is sort of everywhere in terms of that. So let's see if I can find it real quick. I believe it is. Yeah, it's all the way over here. All right. Copyright case law. A very important case is that of Nestle Pak Limited, Lahore, etc. versus Shahriyar Qureshi of 2023. So this is a very recent case. So the parties in this case, respondents, then plaintiffs, so do bear that in mind. The then respondents first initiated a suit against the plaintiffs for damages, asserting that they had collaborated to produce and publish a song holding all right. It has like the cheesiest name. I couldn't bear to write it. It was like something around the lines of like it was really cheesy. It was I couldn't handle it. So anyway, they had published a song holding all rights and interests over it. It was like cheesy, shiny, as it was published and disseminated throughout the public. So the respondents alleged that they were the ones to first create and release the song in 1994, and that the now plaintiffs had remade the song in 2019. So this wasn't just a like a inspired work. This wasn't a parody. This wasn't a cover even of the song. It was like almost verbatim that song in 2019. So having resultantly gained what the respondents felt was undue profit, all without having obtained a license to do so. And so it was not possible that they had acted in good faith or fair use. So these then respondents claimed under the CPC of 1908 for damages, making them now plaintiffs. So reliance by the IPO onto the CPC of 1908 calls for its tribunal to be the proper forum to hear this matter, as per the ordinance of 2000. That's also highlighted in the 2000. So this case basically helps us understand that when it comes to certain infringements, the law guides us on the law guides us on what is the proper forum. Other notable cases include Hilal Foods Limited versus Danpak Food Limited, and Dollar Industries and another versus Mr. Kamran Akhlaq. So these cases, again, they just let us know that that Pakistan likes to stay within its set forums. All right. Now, finally, let's talk about our third kind of intellectual property. Whoa, okay, that gave me that got me a little dizzy. Trademarks. Now, the governing law regarding trademarks and what the IPO likes to refer to is the Trademarks Ordinance of 2001. When it comes to registration and protection, pretty much the same rules. Trademark search, filing the application. In this case, there are TM1 and TM2 forms as well as a TM55 form. It's all pretty technical. They can all be found online, which is pretty interesting. I say that just in case anyone's looking to register their trademark. The forms can be found online, and it's pretty easy to get the particulars in order because of that. So, and there can also be certain co-owners of a trademark, and co-owners get to basically, as per Section 24 of the 2001 ordinance, no one co-owner of a trademark is entitled to use a trademark unless all of them can, meaning all of them may jointly apply to get their trademark registered under Section 22 of the ordinance. Now, those application particulars are assessed by the registrar as per accuracy, credibility, the extent of the specifics included. As I told you guys before, we want to make sure that the registrar, or whatever office we are pitching our intellectual property to, they don't want to ask questions from the get-go. Questions and scrutiny needs to come later, if it even comes at all. So what is the extent of the particulars included? How much information have you given them, right? Is it enough? So if the IP tribunal opines that it is fair and reasonable to, excuse the typo, to correct any error of an application, it will allow the correction for, whoa, excuse that typo too, as long as it will allow for it to be corrected. The IP tribunal and the IPO is a lot more lenient in terms of allowing you, encouraging you as a Pakistani citizen to get your intellectual property recognized through, trademarks, copyrights, that sort of thing, because a lot more than the federal government will. So as you may have been able to figure from now. So that basically helps you to get your trademarks registered, such as all these pretty trademarks here, Coca-Cola, IBM, Barbie, Levi's, that sort of thing, right? They are unique marks denoting a certain good or a certain service. And oh yes, that TM, this TM, I'm pointing with my finger, my goodness. This TM sign is usually the text-wise denoter, as you may have been able to see earlier, like Barbie TM, Mattel TM, HP that TM, that sort of thing, right? It's a little, annotation. So after that comes advertising and publication of the trademark in the journal. And this is presented as a sort of billboard or magazine. Any opposition or disagreement will be addressed within 4 months. Any grounds of opposition include, for instance, an apparent lack of the intent of the applicant to use the trademark in Pakistan, or that it was amended or made contrary to Pakistani trademark law, right? And then after that is analysis of the publication. Once the application is accepted at this point, at stage 5, if you will, the registrar, in accordance with the Trademarks Act of 1940, ensures that it is indeed registrable, that there is no other scrutiny to be made, and it can be published in the Trademarks Journal of the head office of the Trademarks Registry. After that comes fortified registration as per Section 33 TMO 2001, or the Ordinance of 2001. What do I mean when I say fortified registration? As you must have been able to figure by now, when I say fortified registration, we talk about registration that has come out of its seal, its internal seal, right? And it's become known to the public that through the trademarks registry that a certain intellectual property right has been registered. So fees are to be paid as prescribed, as we must know. Trademarks will be registered under the filing date of its application, and the certificate is issued to the applicant with the seal of the trademarks registry, which again acts as prima facie evidence to the proprietor that they have the exclusive rights to that trademark. If this phase is not accounted for within a year after the application date because of any fault of the applicant, not any delay, because again, these things take time, not any delay of the registry, then the registrar will give notice to the applicant, but it will still abandon the application. After its registration, we want to talk about renewal as well, right? Just because you've got an intellectual property right registered doesn't mean that it's always going to stay legitimate or exist within the journal concern. So this has to be done every 10 years as per Section 34 of the ordinance and 35 of the ordinance. As per Section 35, the registrar will inform the proprietor before its expiration date that it will be renewed. Again, very generous. After which the proprietor will request for renewal in the manner prescribed, along with the renewal fees, if applicable, they are. If not done, the trademark will be removed from the registrar of trademarks. And if it is done, then its renewal will be made public in the journal. Let's move a little bit ahead. Yes. So what about trademarks licensing and agreement? Licenses may be general or limited, the latter being in relation to some but not all goods or services for which the trademark is registered, or to the use of the trademark in a particular location of or area. So licenses to a certain trademark could be but sometimes they're limited in terms of design, color, location, that sort of thing. This has to be signed by the grantor or on their behalf. License grants those entitled to the status of successor to the proprietor's title and is binding as such unto them. Sublicenses may also be provided, and exclusive licensees have the rights and remedies afforded to them, just as an assignee's remedies and rights are afforded to them as well. So again, what do these licenses do? They basically help to further legitimize a certain trademark. Now, what about when it's infringed upon? What constitutes a trademark infringement, and how can it be litigated against, right? How can it be litigated against? And yeah, so infringements are constituted when trademarks are used in a manner used to deceive or make others think that they're being owned by the offender, right? Again, the key word here is deceptively similar, right? Certain, let's say, logos might look a little similar. For example, let's see here. Let's see here. Starbucks and let's say Starbucks and Coffee Rocks, for example, as you can see here. Again, I'm pointing with my finger, like I'm a little bit of a boomer, sorry. So Starbucks coffee, this one says Sardar Baksh Coffee and Co. And this one says Coffee Rock. So now Sardar Baksh Coffee and Co. That logo might look a little deceptively similar, but not really Coffee Rocks, right? So an infringement is constituted when a deceptively similar trademark is used, right? Now, innocence, in this case, if you've been accused of doing this, you can be prove this by asserting that you had taken all reasonable precautions in ensuring that the mark was genuinely used, or excuse me, that the mark used was genuine, and that the tribunal itself had already been informed of all details related to whom they got the goods from, or that they had otherwise acted in good faith. Okay? So good faith is sort of one saving grace when accused of violating or infringing upon a trademarked good or service. Infringements can also be done when certain restrictions imposed by the proprietor of a mark, such as prohibiting the application of it onto damaged goods, right, are breached, provided again that you cannot establish that you were acting in good faith. Masalan, if I am selling makeup, right, and I've got a trademark, I've got a logo and a sticker that I put on every single lipstick, for example, that I'm selling, and I find that there's a batch of products that are about to be, labeled and stickered onto and have my trademark onto them, but this batch is, either the formula is not great or the manufacturer has got something wrong with the color of the caps, right, or the lid on the lipstick, that sort of thing. It's an altered or damaged good, right? So I don't want my face, I don't want my sticker on there. So if I have imposed that restriction and somebody has put it on anyway, as long as they can't prove that they did so accidentally or in good faith, I can sue them for that. Good faith can be demonstrated in ways such as using a trademark to signify the purpose of the related product, or for comparative advertising, which is not only perfectly legal, but it's openly encouraged in a free market economy like that of Pakistan. Again, Pakistan is at least on paper, it's a capitalistic society. So if you use a trademark to signify why your product is being used, the mode of its employ, or for comparative advertising, that's perfectly fine. So the proceedings against infringement and the remedies, basically as per section 46 of the 2001 ordinance, is that says that the trademark's proprietor is almost always the proper plaintiff. They're the ones that have the legal standing to bring a claim in the first place. That has to include, necessary information. For example, like I said before, किन laws के अंदर और किस हवाले से और किस कौन सा remedy वो pursue कर रहे हैं, all of that information उन्होंने शामिल करना है in their submission to the court. A high court or district court may issue an order requiring the offender to get the mark removed or obliterated in any way. Make sure it's as if it never happened, right? If the trademark, the infringing mark itself cannot be removed, then any goods onto which that mark has been applied will be removed or destroyed by whomever the High Court or District Court deems fit. All right. So as per section 50, the time after which this remedy is not viable is 3 years from the application date of the trademark onto infringing materials. Again, it's just that normal legal concept of not wanting to wait too long before you try and enforce your right, because the longer you wait, the more incredible your reasons for doing so seem. Generally, of course, that is subject to certain situational exceptions. Now, an order to dispose of infringing goods is also practicable. So again, like I said, not only can the trademark be destroyed if it's infringing upon an already registered trademark, but the good We want to make sure that an infringing trademark is addressed as if it never even happened. We want to make sure it's gone. So any aggrieved party can also seek remedy against groundless threats of suing for infringement. The accuser alleges the accused has infringed a registered trademark as per Section 52. Relief may be in the form of damages or injunction unless the accuser can present reasonable grounds for the accusation. Why is that so significant? It's because we're talking about intellectual property, you people. This is a matter of one's creative and artistic, even sometimes, um, capabilities, and there's also a question of one's reputation at stake here. Right? If you've got a trademark and you're selling products to people, you want to make sure that not only is your registered trademark not infringed upon, and that people recognize it and they recognize okay, this is a good product, this is a good service, right? But you also, if you have been falsely accused, you want to make sure that you can advocate for yourself. Again, we're talking about intellectual property, we're talking about non-tangible property here. We're talking about property that cannot really be proven to be yours as easily as tangible property. If I get a car, if a car that I own is stolen, I only really have to, as far as I know, present the proper, registration papers, my insurance, that sort of thing, to, get people to understand where I'm. But if I own a certain, brand logo, for example, like the makeup situation I provided to you guys earlier or presented, that's a little bit difficult. So uh, not only are those whose trademarks have been infringed against have the legal standing, if applicable, to claim, but also those who have been groundlessly accused of doing so, they can claim as well. That being said, let's talk a little bit about, or let's visit some trademark law, case law. So a very interesting case here is Muhammad Multazam Raza versus Muhammad Ayub Khan and others, 2021. The plaintiff and the respondent one had entered into an agreement whereby international franchises would be managed and promoted under the registered name Zakwari International, which currently manages two brands, Mr. Cod and Ranchers, which I've been to. It's Mr. Cod and Ranchers are I believe Ranchers doesn't exist anymore. I could be wrong, but I think Mr. Cod still does. Now, that's relevant because given the decision of this case, right? As we will talk about, as I will talk about with you guys, what it means to pass off, right? So the letters, I believe, the decision of this case helped to influence Ranchers not existing anymore. Anyway, the latter's trademark, Rancher's trademark, was registered complying with the Trademarks Ordinance of 2001. Now, respondent one entered into an agreement with Manor to operate a rancher's restaurant in Markaz, Islamabad, and the respondent number two joined, making this a joint venture agreement or tripartite JVA, all without the plaintiff's consent. So this was literally the same wording for ranchers. Respondents one and two later joined with respondents three, a private limited company named Ranchers Cafe. Again, deceptively similar logos here. Hence, the contended impression that this cafe was affiliated with Ranchers. IPO Tribunal had jurisdiction over this matter as per Section 17, 18, and 39 of the IPO Act of 2012 to cognize of this case and to redress it, right? Given the respondents' acts fall under Section 24 and 40 of the TMO 2001, they were intending to use a trademark that was not their own to effectively offer goods and or services. Again, this is a fraudulent and deceptive act. So this sets and upholds the maxim that a trademark's true owner is to be protected from passing off attempted by others, using the using the owner's trademark deceptively before the general public. Other notable cases include Shizan Services Private Limited versus Shizan Bakers and Confectioners. I'm sure you can tell why that case exists, and Hamdard Laboratories, Waqf Pakistan versus Muhammad Fahim, 2014. and Pioneer Cement Limited versus Fecto Cement Limited, etc. of 2012. So this was basically the gist, if you will. This was my presentation. I will be happy to share the link to this presentation with Mr. Anil Megani. I would love to do that in case you guys ever want to refer to this. And you're obviously welcome to take down notes, do whatever you'd like with it. This is fair use. I'm giving my full consent to that. So let me go ahead and stop sharing my screen. Go back to just addressing you guys in just 1 second and go ahead and stop sharing. It's taking just a little while. Sorry guys, my this Zoom application is a little iffy.
Excuse me, ma'am. Ma'am, what are you stuck with? Do you want to cancel the sharing of the screen?